Gun laws in Georgia regulate the sale, possession, and use of firearms and ammunition in the state of Georgia in the United States. Overview. On June 8, 2010, Senate Bill 308 was signed by Governor Sonny Perdue reforming and clarifying many of Georgia's gun laws, while leaving certain restrictions in place. While Georgia is generally considered to be a shall-issue state, the actual Georgia Firearms Permit statute requires the permit applicant to obtain approval of the local county probate court judge, who can deny issuance based solely on a determination that the applicant is not of good moral character. Georgia recognizes permits from any other state which recognizes Georgia's permit. Any person who may legally own a firearm may carry a firearm in their home, place of business, and vehicle without a permit. Any person who is not prohibited by law from possessing a handgun or long gun may have or carry on his or her person a long gun without a valid weapons carry license, provided that if the long gun is loaded, it shall only be carried in an open and fully exposed manner. OCGA. A section November 16, 126, state preemption laws prohibit localities from regulating the ownership, transportation, and possession of firearms. Georgia also has a law preventing localities from enacting ordinances or lawsuits to classify gun ranges as nuisances. Firearm regulations are uniform throughout the state, and a firearms permit is valid throughout the state, in all areas other than in a few specially defined areas. These specially defined prohibited areas include, in a government building, where ingress into such building is restricted or screened by security personnel, in a courthouse, in a jail or prison, in a place of worship, unless the governing body or authority of the place of worship permits the carrying of weapons or long guns by license holders, in a state mental health facility, on the premises of a nuclear power facility, within 150 feet of any polling place, in any school building or on school grounds, unless permitted in writing by an official of the school, private property, where the owner or person with legal control of the property has declared it to be a gun-free zone. As exceptions to the above list, a person may keep their firearm in a locked compartment of their vehicle at any of the above places except nuclear power facilities. Also, a person may approach security or management of any of the above places and ask them for directions on removing, securing, storing, or temporarily surrendering the weapon. As of July 1, 2006, Georgia became a stand-your-ground state, and requires no duty to retreat before using deadly force in self-defense, or defense of others. Georgia law allows private firearm sales between residents without requiring any processing through an FFL. A Kennesaw, Georgia City Ordinance requires that all homeowners own a firearm and ammunition. No one has ever been charged with violating this ordinance. An amendment exempts those who conscientiously object to owning a firearm, convicted felons, those who cannot afford a firearm, and those with a mental or physical disability that would prevent them from owning a firearm. House Bill 60. As of the 23rd of April, 2014, Georgia's gun laws were drastically revised when Governor Nathan Deal signed House Bill 60, or the Safe Carry Protection Act, into action. Law changes. The Safe Carry Protection Act changed many of the currently enacted gun laws in place beforehand. Summary table, see also. Law of Georgia, references.